relief for couples who are awaiting divorce. Well, what happened is a 5-judge constitution bench of the Supreme Court has ruled that marriages between two consenting parties can be dissolved on grounds of irretrievable breakdown. Now, the top court has announced its verdict on a batch of petitions relating to exercise of its vast power under Article 142 to dissolve the broken marriages between, of course, consenting couples without referring them to the family courts. Now, today's ruling makes it clear that the 6-month period of waiting under the Hindu Marriage Act for the divorce can be dispensed with it in case of irretrievable breakdown of the marriage. Now, couples don't have to approach the family courts in such cases. My colleague Harish is joining us back to give us more details. Harish, indeed a big relief for couples who are awaiting divorce. Now, the Supreme Court has fast-tracked the entire matter and said that, parties' marriages rather can be dissolved on grounds of irretrievable breakdown.
Yes, that's right. Very significant landmark judgment on from a constitution bench. The Supreme Court's thrust was that a totally broken down marriage, which is emotionally dead and which cannot be salvaged. Such couples, their agony should not be prolonged using the process, and it should be fast tracked. And so, in fact, the Supreme Court, in a very significant judgment, has said that the Supreme Court itself can, using Article 142, which gives them inherent powers, special powers to pass any order to secure justice for any party. So that can be used in divorce cases also if the Supreme Court deems fit that this particular case the couples need, and there is a mutual consent, and if the couples need an early divorce, it can be given under Article 142, and such and prolonging the process through the proper hierarchy, which was till now being followed, like a cooling period between 6 months and 18 months. They languish in the family court, and if the aggrieved side once appeals to the High Court, then comes to the Supreme Court. This process is very time-taking process, which only prolongs the agony of both sides. So, Supreme Court has said that it has inherent powers to give instant divorce to such couples to lessen their agony, and this Article 142 can be used, and the mandatory rule that they should approach the family court where there is a cooling period of 6 months, and after which only the process will begin, that can be dispensed with in the interest of justice. And the very significant observations have come in the judgment which has just been uploaded. It says the time gap is meant to enable the parties to cogitate, analyze, and take a deliberated decision. The object of the cooling off period is not to stretch the already disintegrated marriage or to prolong the agony and misery of the parties when there are no chances of the marriage working out. Therefore, once every effort has been made to salvage the marriage and there remains no possibility of reunion and cohabitation, this court is not powerless in enabling parties to avail a better option. So very significant observations found in the judgment which has just been uploaded. And not only this, the Supreme Court queried why this, despite 3 law commissions in 1974, 78 and 2008 recommending that irretrievable breakdown of marriage should be
Harish,
included as a
point
ground
taken.
for
We will be coming back to you for more details on this. But as of now, we'll have to move forward. We are, of course, bringing